It's very good to see you all here. Very pleased that you're able to get here. Sorry that so many of you had such difficulty getting here. I understand there were trouble on the M11 or the M25 or whatever the road was, but we're really delighted that you're all able to come. I'm Maurice Sunkin, and on behalf of the University of Essex, I'd like to thank our hosts, Clifford Chance, for providing the facilities for the lecture and for acting as our hosts. We're very grateful. As I'll say in a moment or two, this is a very well-established and distinguished set of lectures. The lectures were established, in fact, in 2002, and since then they've provided an opportunity for us to hear from the leading and most distinguished lawyers and from those who have interests in the law on topics of central importance to our time. And the first lecture was delivered by Lord Bingham in 2002 on the issue of liberty and slavery, and Lord Bingham set the standard both in terms of the quality of the speaker and the importance of the subject. That has been met by subsequent lecturers, and we have had a very long and distinguished list of lecturers. Amongst them are some people who are here. I'll mention some names, but please forgive me if I don't mention all names. Lord Hope has given a lecture on torture, Lady Justice Arden on human rights and terrorism, Lord Justice Laws on the Constitution and rules of recognition, Lord Phillips a lecture on homicide, Lord Mance on piracy and terrorism, Lord Dyson has given a lecture, Sir David Anderson QC. Earlier this year we had a lecture from Lady Justice Gloucester. So we've had a very long and distinguished set of lectures. Alas, this is to be the last of the lectures in the Essex Clifford Chance series, and we at Essex are very sorry about that, but we're very grateful and pleased that we've been able to collaborate with Clifford Chance to provide these lectures. I say this is the last of the lectures, but perhaps I should say that we've now reached the grand finale of the lecture programme. This evening we're really very fortunate and honoured to have Sir Jeremy Sullivan give the lecture, and he's, as you will all know, I expect, one of the most distinguished public lawyers of our age. He was an outstanding judge, and no one is more expert in the topic that he's going to address than he is. Just some brief biographical background. Sir Jeremy Sullivan was called to the bar in 1968. He practiced at the bar principally as a planning lawyer before becoming a High Court judge and a Lord Justice of Appeal in 2009. And in 2012, he became the senior president of Tribunals. We're very sorry that in 2015 he retired, although maybe he and his wife are not quite so sorry, I don't know. During his career as a practitioner and particularly as a judge, he gained a reputation for being a steadfast supporter of the rule of law in the face of the abuse of power by the executive in particular. He wasn't always, I think it's fair to say, the most popular judge as seen from the perspective of the government. He was an extremely popular judge for many of us, however. I think that on one occasion his judgment so irritated and upset the executive that the then Prime Minister, Tony Blair, she described one of his judgments as an abuse of common sense. That was in response to Sir Jeremy Sullivan's finding that the government had abused its legal power. To attract the criticism of the Prime Minister, I think, is a great achievement for any member of the judiciary, and to be applauded. We very much look forward to the lecture this evening. He's going to talk about administrative law over the past half century or so, and you've come to listen to him, not to me, so without further ado, I will pass over to Sir Jeremy.
Maurice certainly knows how to build up a speaker so as to put the fear of God into him. The case that he mentioned earned me the title in huge headlines in The Sun of Legal Ass Number 1. Happy to say the Court of Appeal kindly described the judgment as impeccable, so whether that meant that the Court of Appeal was Legal Ass Number 2, I don't know. It's very gratifying to see the number in the room. I think there are probably about 10 times more students of administrative law in this room than there were administrative lawyers 50 years ago. I didn't start my administrative law course, in fact, I suppose we'd probably now call it a module, at LSE under Professor Griffiths until October 1966, so it's not quite 50 years, but I claim my half century of administrative law because it was back in 1965 that I decided that for the final year of my LLB, I was going to choose an option that involved the least amount of work and preferably the least amount of law. And administrative law in those days was the obvious choice for me. By then I'd endured a year of what I think one could charitably call a traditional law degree, which seemed principally to involve learning by rote endless numbers of cases. And I think looking back, I'm convinced that 50 years ago, I'm sure it's all changed by now, the London LLB course was quite deliberately constructed to be as boring and tedious as possible. It was a strategy to weed out those faint hearts who did not have a sufficiently dogged determination to persist and pursue a legal career. Well, I wanted a legal career, I knew that, but I wanted a legal career without too much law in it. And 50 years ago, I have to say, administrative law filled the bill precisely, because at that time, there were very few administrative law cases. There were a couple of mercifully slim textbooks. All of the important cases, of which there were not very many, had been conveniently gathered together in a book that was really a revamped PhD thesis by a chap called De Smith. And what you have to remember is that at that time, 50 years ago, academics like Maurice were still debating whether there was such a thing as administrative law. There certainly was law, and there was administrative discretion. And 50 years ago, there was a great deal of administrative discretion vested in the many organs of the state, largely a hangover from the war years. Our lives were ruled by monolithic public bodies, government departments, local authorities, nationalised industries, running numerous services, water, gas, electricity, telephones, tramways even, railways and so forth, all of which are now privatised. And of course, we had the NHS and quangos without number. And I think, was it Philip Larkin who said that sex began in 1963? Well, I can say I think that administrative law was just a bit behind sex in that respect, certainly in 1965. What was it like then? I mean, obviously there was no administrative court, there was no administrative law bar, And 50 years ago, if a public authority said jump, well, as a citizen in a very deferential society, you jumped. You didn't say, well, you haven't consulted me about whether I should hop or skip or jump. Or I've got a legitimate expectation that I should not have to jump. Or jumping would be discriminatory or even disproportionate. You simply jumped. And such was the dearth of what I'd call real administrative law then, as opposed to good administrative practice, that the administrative law course had to be padded out with what seemed to be at least quite a lot of topics that were really non-legal topics. They included, of course, tribunals. We'd had the Franks report, but tribunals were not then regarded really as part and parcel of the legal system. They were part and parcel of the sponsoring government department's administrative process, although, of course, they did have to behave in a quasi-judicial way, unlike the rest of the administrative process. We looked in the course at the then novel concept of the ombudsman, and we considered whether this foreign idea might be of any use in the United Kingdom. We also had a look at the prospects for local government reform, much needed by then because, of course, we still had the authorities, most of which dated from the 1930s at the latest, urban district councils, rural district councils, municipal boroughs, county boroughs, so on and so forth. So, the administrative law course then seemed to a very large extent to be a pretty large dollop of public administration with a bit of law thrown in on the side. So it was obviously just the course for me. It would be really rather an interesting diversion because unlike most of the other third-year options, which were very closely allied to future practice, either at the bar or solicitor, company law, commercial law, conveyancing, and so on, it's quite obvious that administrative law was going to be of absolutely no practical use whatsoever in terms of actually earning a living as a lawyer. Well, so that's what I thought 50 years ago. Half a century later, I think it must be fairly obvious that things didn't quite work out like that. So whatever your expectations are as students, just think 50 years on, they might not quite work out as you think they will. And indeed, one of the non-legal topics that we considered, tribunals, of course, came to assume quite a large importance in my legal life. I think, to sort of sum it up, looking back over 50 years, I feel rather like the novice surfer. A surfer of the ocean waves rather than of the internet, I hasten to add, who finds himself a nice, inoffensive, quiet little wave, and somehow is just inexorably then swept up onto the crest of some huge tsunami that sweeps all before it. And certainly the rise of the administrative law tsunami over the last 50 years has been very good to me in the space really of one professional generation. We lawyers have created a very extensive, not quite comprehensive because it's still expanding, body of administrative law. So there's no longer any such thing as an unfettered discretion. We now know that any discretion has got to be exercised so as to further the purposes of the enabling enactment. And since the enabling enactment is almost invariably silent as to what its underlying purposes are, or at least somewhat gnomic as to what its purposes may be, the courts are there, helpfully, to tell you what the real purposes of the Act are. We've swept away the concept of the quasi-judicial administrative decision, the type of administrative decision where certain standards of procedural fairness had to be observed. So, lawyers' concepts of what is required by fairness, in inverted commas, now apply to all and any administrative decision. Indeed, of course, the rather more nebulous concept of fairness has completely eclipsed the old idea of natural justice. So, given the need for fairness, we now have concepts such as legitimate expectation, not just as to the process to be followed by the administrator, but sometimes as to the substantial outcome to be achieved. And of course, the lawyers are there on hand to tell you, they'll tell you after the event, of course, whether your conduct as an administrator was such as to engender a legitimate expectation, and if it was, what you've got to do to honour that expectation. Fairness may require the administrator to give reasons for his or her decision, even though the statute didn't suggest that reasons were really required. And again, the lawyers will be helpfully on hand to tell you whether or not you ought to give reasons, and if you ought to, whether or not your reasons are sufficient. Unfairness, if it is sufficiently egregious, may be unlawful. And as a matter of fairness, principle now is, of course, that there should be consistency in administrative decision making. So if there is a policy, then the policy must be followed unless there's a good reason to the contrary. I hear you ask, well, who says whether or not the reason to the contrary is good enough? And the answer is, generally speaking, the courts. An administrator's view of what his own policy means might be a perfectly reasonable view. But of course it may not be correct, we now know, because as a result of helpful guidance from the Supreme Court, we now know that just like words that we find in enactments, words that we find in policies have one and only one correct meaning. And the words mean what they say. And of course there aren't any prizes for guessing who decides what the words say. It's certainly not the author of the policy. And we've also, of course, got to the position now where errors of fact may in certain circumstances amount to errors of law. Now, I could go on, but it must be perfectly obvious that after half a century of innovation by administrative lawyers, the possibilities of legal error in administrative decision-making are now multifarious, and they extend way, way beyond a simple misinterpretation of the enabling legislation. And as lawyers, we tend to be very proud of this achievement. And certainly in terms of job creation, it has been a huge achievement for lawyers. But lawyers, perhaps sometimes like other professions, do have a tendency to equate their own interest with the public interest. Now, since I'm no longer earning my living from administrative law, having retired, I thought I'd just act as devil's advocate for a while. So tonight I want to pose what might be thought a heretical question in this company, a question for consideration by the University's UK Administrative Justice Institute. It's this: have the legal constraints on administrative decision-making which we've managed to introduce over the last 50 years actually resulted in a better quality of administrative decision-making? Or has their principal effect been to create uncertainty, delay, and most certainly huge expense? In short, have we managed to cast a legal blight over speedy and effective decision-making by administrators. I put it to you that we have managed to blur the line between administrative and judicial decision-making by imposing procedural requirements in the name of fairness, which are appropriate to the latter upon the former. We've managed to blur the line in practice between discretion and duty. I quite understand that the distinction remains in theory. I'm talking about practicalities. And in practical terms nowadays, the exercise of a discretion may be hedged around with so many legal constraints that sometimes it's really quite difficult to see what room there is for genuine discretion. For example, the extent of a discretion, the room for manoeuvre, may in practice be eliminated, not merely constrained, by a legitimate expectation. I also suggest we managed to blur the distinction between policy and law, not simply by interpreting policy as though it was law, despite the fact that it's very often drafted by non-lawyers and not by parliamentary draftsmen, but also because we have created legal obstacles to departures from policy. Once, of course, that policy has been helpfully interpreted by the court. That is to say, the need to give legally adequate reasons, the need to respect legitimate expectations, the need for consistency in administrative decision-making, and so on and so forth. In a nutshell, I suggest to you that over the last 50 years, we've managed to expand the concept of unlawfulness so that it now embraces administrative failings or errors that would, 50 years ago, have been regarded as examples of poor quality or shoddy administration. Now we've got an ombudsman maladministration, if one wants to call it that. I'm not for a moment suggesting that administrative errors or shoddy administration is not worthy of criticism. My point is that 50 years ago, many of what are now legal errors would have been the kind of errors for which the decision maker, or very often the decision maker's political master, would be politically accountable, if indeed they were accountable at all. But now, these errors amount not simply to unfairness, but to unlawfulness, which is liable to be struck down by a court. It is sometimes said that doctors have managed to medicalize certain types of behavior that people find slightly unsettling or undesirable. So the doctors give them a name and you get pills for them or whatever. Well, I think in a similar way, so over the last 50 years, the lawyers have been busy lawyerizing unsatisfactory administrative behavior. And so the conspiracy theorists among you can see that there has been a very successful conspiracy of professionals over the last half century. And just as we've had an enormous expansion of the grounds on which a defective administrative decision may be found to have been not just an unsatisfactory or an unfair administrative decision, but a positively unlawful one, so too has the type of administrative decision which is susceptible to judicial review been greatly expanded. As I mentioned, the category used to exist of quasi-judicial decisions, as it were, an intermediate position between administrative decisions and judicial decisions. Once we jettisoned that intermediate category of the quasi-judicial decision, then any administrative decision, all administrative decisions, become fair game for the administrative lawyers. I think it is fair to say that half a century on, there is now no administrative nook or cranny that is safe from rash assault by administrative lawyers. You only got to look at the papers to see how often it is that some new policy initiative or administrative decision immediately provokes either an actual or a threat of judicial review. Allocations of funds for police authorities, for example, or in today's paper, the contents of the religious studies syllabus in the academic curriculum. And so that we find really that judicial review has become a proxy for political challenge to controversial policy decisions. And very often, of course, the threat of or the actual commencement of judicial review proceedings leads to the discovery of factual rather than legal error. For example, the collapse of the railway franchising allocation. I readily acknowledge that I was very fortunate over the half century to practice as an advocate. Perhaps I viewed it slightly differently when I became a judge. But anyway, so far as an advocate, I was very fortunate to practice during periods when the government of the day had a massive parliamentary majority. Time under Mrs. Thatcher in particular, and when I was a judge, there was then a time under Mr. Blair. And during those periods, political challenge was effectively stifled under our system. And so what were essentially objections to political objections to political decisions were pursued by judicial review, which was acting perhaps as a useful safety valve. Of course, I quite appreciate that many of the threats to institute judicial review proceedings never materialized, didn't come to anything, or if application was made, then permission to apply for judicial review would be refused by the court, or if it was allowed to proceed, then the claim was eventually dismissed. I think the important word there is eventually dismissed, because the mere threat of judicial review, or the fact that an application for permission has been made, or a substantive application has been made and remains undetermined, has the effect of causing delay and uncertainty. I quite accept that sometimes administrative law's delays can be entirely beneficial. I asked the question, what have the Royal Opera House and Marylebone Station got in common? One opera, the other trains. I like both, not necessarily in that order. That is not the answer to the question. The answer to the question is neither of those buildings, institutions, would be the same today if it were not for the law's delays. Delays caused by unsuccessful judicial review proceedings. The original proposals for the redevelopment of the Opera House included a massive office block as enabling development, and the office block would have towered over the Opera House and the restored Covent Garden, being very, very intrusive. We spent so long in court arguing over whether the enabling development was lawful that despite the fact that the court eventually decided that it was lawful, it was a decision of the Court of Appeal, by then the economic climate had changed, the office block had become unviable, wiser thoughts prevailed, and so happily we have Jeremy Dixon's scheme for the Opera House with us today, with no horrid tower. How many of you possibly not too many in this room, would remember British Rail's proposal to close Marylebone Station and convert the tracks to a busway. Mrs. Thatcher was very keen on that idea, and closure proposals were published. So, on behalf of the local authorities, we challenged the Transport Users Consultative Committee's refusal to allow us to cross-examine British Rail at the closure hearing. We submitted that was contrary to natural justice. We still called it natural justice then. The woolly old concept of fairness came along a bit later. Now, you may say, well, that's a pretty hopeless argument. Indeed it was. It was eventually thrown out by the Court of Appeal, but only, of course, after a substantial delay, which had given time for there to be yet another change in rail policy, and happily Marylebone still flourishes, and we came into it today. So there are examples of wholly beneficial effects of the law's delay, but of course they're purely serendipitous. And certainly in my experience over the years, there have been a number of worthwhile proposals which have been delayed, sometimes indeed completely frustrated by judicial review challenges or the threat thereof. The huge expansion in both the content and the reach of administrative law hasn't been affected by some overarching enactment or code. It's been achieved over the half century, case by case, in a multitude of incremental steps, each of which may well have been wholly justified upon its own particular facts. And what we've not done, and perhaps what the Institute might like to do, Maurice, is to stand back and assess the overall impact of the legal edifice which we have created over this half century on the practicalities of administrative decision making. And I just pose a couple of questions for the Administrative Justice Institute to consider. Have we over-legalized non-judicial decision making? Whether the answer to that question is yes or no, on any basis, there has been a huge amount of administrative law that administrative lawyers have created over the last 50 years. And what effect, if any, does this have on the ability to make timely and effective administrative decisions? And I think allied to that, there's a further issue that would be worthy of some study. Because having created this large body of administrative law, I suggest that we have yet to create a mechanism for resolving the increased number of what we now classify as legal disputes, not just administrative failings, but legal disputes, in a process that is both expeditious and proportionate. When I started as an advocate, if you wanted to challenge a decision by a public authority, you went along to the divisional court, which was presided over by the Lord Chief Justice of the day, and you were squeezed into what was a pretty heavy list of case-stated appeals, usually from magistrates' courts, and you asked politely for one of the prerogative writs, certiorari, mandamus, or prohibition. And it's fair to say that that forum wasn't a terribly fertile ground for the development of a sort of a coherent body of administrative law. Well, of course, all that changed with the establishment of, first of all, the Crown Office list, and now the Administrative Court. But, notwithstanding those procedural improvements, I suggest there are two characteristics of judicial review proceedings that have persisted. After 50 years, they are still horribly expensive and very slow. So far as the speed of proceedings is concerned, perhaps because of the hugely greater number of cases, I'm bound to say, as a matter of impression, they don't seem to go very much faster now than they did 50 years ago. And so far as expense is concerned, frankly, looking at costs bills, as we do in court, they do seem to be very much more expensive, even allowing for the effects of inflation. Just as an aside, it's always struck me as very odd. This is one area where market economics plainly does not work. There are hugely more lawyers than there were 50 years ago. The bar, I think, has expanded something like tenfold since I was called in 68. There are now, I think, probably more barristers than there were solicitors 50 years ago. But oddly enough, the cost of lawyers does not appear to have come down. You would have thought the supply and demand would have had some effect, but it doesn't. When I was chairing the Access to Environmental Justice Working Group, we looked at the cost of conducting environmental litigation in other European countries that were signatories to the Aarhus Convention. That's the convention, you remember, that requires the signatories to it to ensure that ordinary members of the public have access to legal procedures to challenge the lawfulness of environmental decisions, and those procedures must not be prohibitively expensive, amongst other things. We found that the costs of judicial review proceedings in environmental cases in England and Wales were simply astronomical compared to the cost of going to law in similar cases in other European countries. And we formed the view that the United Kingdom was undoubtedly in breach of the Aarhus Convention, and said so. Somewhat reluctantly and a bit belatedly, the government recognised that this is indeed a characteristic of our system of administrative law. So now, in the civil procedure rules, we have a special costs regime for environmental judicial reviews to ensure that they are not prohibitively expensive. Now, my point is not to consider whether or not that regime actually achieves its stated aim. There are some who would suggest it does not. My point is this, that if you have to have that regime to make environmental law challenges not prohibitively expensive, it simply confirms that the costs of all other non-environmental judicial reviews are likely to be prohibitively expensive for the ordinary member of the public. Having been to turn from cost to delay, having been on the receiving end of judicial review proceedings myself in my capacity as Deputy Chairman of the Boundary Commission, I can certainly confirm just how disruptive they are in terms of the decision maker's time, and just how very frustrating they are in terms of unnecessary uncertainty and delay. I say unnecessary because, of course, happily, the application for permission to apply for judicial review of the Commission's decision was rejected on the papers, just as well for the judge who took that decision. So I've got no particular axe to grind in the matter. I would simply say, of course, that the Commission's decision was an eminently sensible one. It was to abolish a very small constituency of an MP who shall be nameless. He got a replacement constituency and became Shadow Chancellor of the Exchequer. Sadly, he lost the replacement constituency at the last general election. So what I say is, my message, beware of the curse of Sullivan. Developing a comprehensive system of administrative law over the last half century isn't much use to John and Joan Citizen if it's inaccessible to them, and if, insofar as anyone can access it, it's sclerotic in its operation. And I think as an answer to accessibility, we can sensibly dismiss the prospect of legal aid being one of either this government's or indeed any government's priorities in an age of austerity. Not sure in the light of the statement yesterday whether this still is the age of austerity, but anyway, the Ministry of Justice is going to have a 15% reduction in its budget over the next 5 years, so I actually thought that's as close to austerity as anyone needs to be. Anyway, rather than bemoaning the fact that we're not likely to get any increase or revival of the former amount of legal aid, I think we ought to be asking ourselves the question, would a system that relied on substantial amounts of legal aid to make it accessible for the ordinary citizen who wishes to challenge a decision of a public authority be unduly legalistic in any event? Now, I quite understand that each small step in the creation of this great corpus of administrative law has been justified by the lawyers and the judges under the overarching rubric of fairness. It's said to be the golden thread that runs through administrative law. Now, it's a nice, flexible concept, so the judges, of course, have been able to expand it at will. So it's only fair to give effect to a legitimate expectation. Fairness may require reasons to be given. Fairness may require a hearing. Fairness may require a public body to reconsult, and so on and so forth. And in the abstract, of course, it's very difficult to quarrel with the proposition that administrators should act fairly. I would simply say that, of course, there are all sorts of things that we should do, and we don't, and there are all sorts of things that we shouldn't do, and we do. This may be very undesirable, but they're not unlawful in each and every case. So, putting to one side, it seems to me a wider question as to why unfairness should be unlawful on the part of an administrator or a politician in his office as opposed to a judge sitting in a court. Put that to one side. One thing I would ask you to consider is whether our present adversarial process is the best way of deciding what is or is not fair, in inverted commas, in the public law context. Now, in the private law context, disputes between private citizens, the intense focus on the rights of the individual parties, that's quite understandable. However, in the context of public law proceedings, while the court is on the one hand able to focus very well on the impact of the administrative decision on the individual claimant, it doesn't seem to be so well equipped to assess what's perhaps a more diffuse impact on the wider public of having a decision or policy quashed or delayed. And that wider impact actually might be no less unfair, in inverted commas. I just to give one example, the potential unfairness to the wider public of delay and uncertainty was particularly acute in the planning field. It's a field where it is particularly important in the public interest that everybody knows where they stand when there has been a planning decision, whether the decision is for or against any particular form of development. And prior to the establishment of the planning court, delays in determining planning challenges or challenges to planning decisions, whether they were made by way of judicial review or statutory appeal, were absolutely notorious. And actually it was extraordinarily embarrassing because, of course, it was under the rules, the court was insisting on any challenge being brought promptly, or in the case of statutory appeals, 6 weeks. The two timescales have now been aligned together. So the court was saying, get on with making your application. And then the court itself proceeded to take well over a year to resolve the dispute. And then you could easily add another year if the case went on to the Court of Appeal. And of course, this was a vicious circle, because the ability to cause substantial delays simply by making a pretty baseless challenge was well known and taken advantage of, simply encouraged more hopeless applications, which led to more delay. Now, happily, since the planning court was established, the delays have greatly reduced. But I think there's a lesson, a wider lesson to be learnt from this. The planning court works well now because the planning judges have the necessary expertise to manage the caseload effectively and expeditiously. Really active case management is possible. And I suggest that if we want to speed up the process, judicial review process, the administrative law process, and reduce the costs for litigants in administrative law cases, we must make much more use of the expertise of the tribunal itself. I deliberately say tribunal rather than court, because tribunals do have a particular characteristic, that they do have expertise in the particular subject matter with which they deal. I think we do have to face the fact that our traditional adversarial process is horribly expensive. Each party has to buy in effectively its own expertise. And so what we should be trying to do is to ensure that the court, or I suggest it, the tribunal, possesses the necessary expertise and is therefore in a position to adopt a much more investigatory process. I mustn't say inquisitorial, because it simply frightens the horses. But if one talks about the investigatory approach, I think it's particularly appropriate for resolving public law disputes between the citizen and the state. Any adversarial system works, and only works really, if the adversaries are reasonably evenly matched. So in any adversarial system, the individual citizen is almost always going to be at a disadvantage vis-à-vis the state, in the absence of shed loads of legal aid. And as I've said, you can kiss goodbye to any idea of there being much more legal aid. So what do? Well, I do think that courts, both courts and tribunals, have much to learn from the success of the Ombudsman model, now nearly half a century old in the United Kingdom. I probably said in answer to one of the questions that I saw no possible use for it. This newfangled idea, it was a foreign import and we certainly shouldn't have it here. Once again, one's proved to be wrong. I mean, the Ombudsman used their own expertise to resolve complaints in a cost-free environment, using simple, straightforward procedures that can be navigated by ordinary users without legal assistance. And I think the proliferation of ombudsman schemes, the volume of cases that they deal with, and the apparent user satisfaction with the schemes is perhaps a reflection of the unsuitability of the adversarial model for resolving really a very large proportion of disputes between the citizen and the state. And if I'm correct in my view that a large number of what we now call legal errors are actually maladministration writ large, particularly egregious administrative errors, as opposed to what I might call the traditional type of legal error, misinterpretation of an enactment or whatever, then the need to look very closely at the merits of the Ombudsman model in the reform programme for courts and tribunals that was announced by the Lord Chief and the Lord Chancellor, I think is all the more pressing. Another point for the Institute to note, Maurice, There are two other features I just want to mention briefly about the Ombudsman model. First, the lack of an oral hearing, oral hearings being the exception rather than the rule, and second, flexibility of remedy. I suggest that in the courts, perhaps to a slightly lesser extent in tribunals, we still attach far too much importance to oral hearings. When I started as an advocate, of course, doing judicial review and statutory challenges, there were no skeleton arguments. There was no pre-reading by the court. It was all oral argument. I actually remember my first skeleton argument. I think it must have been about 1980. It was in the case against Andrew Collins, and the skeleton was 1 page long. It was a horribly complicated point about changes of use in the planning case, and I didn't really understand the point. I had to write the point out in order to be able to understand what on earth it was. And having written it out, and therefore I thought fixed in my memory, I thought it might be helpful to hand the page to the judge, and so I did so. Well, of course, now any oral submissions are simply the tail end of a process that's been very largely conducted by means of written exchanges. Skeletons, as we all know, have become less and less skeletal. We've had the photocopier superseded by the computer and so forth. Now, thinking of computers, whether thinking of the students as potential professionals, you're all going to be replaced by artificial intelligence over the next few years. I have absolutely no idea. It doesn't affect me, having retired. And as possibly the one person in the world who doesn't own a computer, the whole thing's a bit of a mystery to me, but one thing is clear to me, that most dispute resolution between the citizen and the state will take place online, via online exchanges, with oral hearings being the exception rather than the rule. And where hearings do occur, they will simply be an element of the overall process rather than the be-all and end-all, the process itself. It does seem to me that a generation which deals with its banking, shopping, socializing, dating, and it would appear all sorts of other things besides, which we needn't mention, online, is going to consider it very weird, actually, to actually have to physically turn up in a room somewhere to have a legal dispute sorted out. I think where we do have hearings, they're going to be much more akin to round-table type discussion, investigations led by the tribunal itself using its own expertise. It's happened in the planning field. When I started, public inquiries were modelled on courtroom procedure. There was really no other role model. So we spent hours and days of completely pointless cross-examination because the proceedings simply ignored the fact that the inspector actually was an expert in his field. And over the last 50 years or so, the planning inspectorates gathered the confidence to move away from court-like procedures. And so most cases are now dealt with on the papers. Where they're not and a hearing's necessary, it's effectively a round-table discussion led by the inspector who asks the questions he or she wants the answers to. As we all know, the same model is applied on a larger scale when dealing with nationally significant infrastructure projects, most unfortunate acronym INSIP, so the large power stations and so on that are proposed. An expert panel probes the issues that it wants examined in compliance with a very tight timetable. I've heard criticisms from some lawyers that this is all very superficial. I think the one thing you could never have said of the old-style public inquiry that used to go on for months, if not years, in some cases, years in the case of things like Sizewell and so on, it certainly wasn't superficial. The wheels ground exceeding small. Whether that was of the slightest use so far as the eventual decision is concerned, I think is open to question. I'll just turn briefly to flexibility of remedy. I don't see the courts rowing back after this development of administrative law over the half century, and the courts saying now to administrators, well, you decide how much reasoning you think you should give. You decide what your policy really means. You decide whether you really do need to give effect to an expectation and so on. I just don't see the courts doing that. So the full range of potential legal errors, I suspect, is here to stay and will probably be expanded. And so just question as to whether the court's response to legal error could not be a bit more nuanced, depending upon the type of legal error. I'm not here referring to what I call the classic legal error. That's doing something that the statute positively says you should not do, or must not do. I'm talking about an administrator doing something that he is allowed to do by statute, but he simply doesn't give adequate reasons for it. He doesn't take account of factor X, Y, or Z, or takes account of other factors that he shouldn't, or doesn't give enough information in a consultation, or whatever. And because the court can't investigate under present procedures the significance of the particular legal error in the overall decision-making process, what we tend to do is to lump all legal errors together, and so we take very often a legal sledgehammer to quash what might be a pretty insignificant nut. And certainly as a judge, when quashing decisions for legal error, I've not infrequently been left with the very firm impression that actually it was all pretty pointless, because it was most unlikely to lead to a different decision in the end, and the real practical effect was simply to prolong uncertainty and certainly to increase cost. As an example, I do remember Prime Minister Blair's response when I quashed the government's consultation into the possibility of nuclear power. Consultation had been promised in the white paper, and frankly it was done in a thoroughly cack-handed way. So I said it was unlawful, and the Prime Minister's response when the judgment was given was to say that of course the government would reconsult, but of course the decision would be exactly the same. Now, legally you might say that probably wasn't the wisest thing to say. No doubt if he'd come along to Clifford chance, he'd have been told that he ought to be just a little more cautious in his utterances. On the other hand, whilst unwise, it was entirely realistic. The government did reconsult, and the decision was entirely the same. And I simply ask you, how often is that repeated after the expenditure of untold time and treasure? It may sound a bit heretical, but borrowing from the Ombudsman, might it be actually less unfair, in inverted commas, to the wider public to allow some kinds of unlawful, in inverted commas, decisions to stand, and simply to give suitable recompense to the complainant or complainants, perhaps an acknowledgement that an administrative error had been made, an apology, and maybe in certain cases, if appropriate, some sort of financial compensation. Now, I know you don't want to keep you from your drink. Just a word, I must say a word about tribunals, since I see it says that I was a former senior president. The white paper that proposed the tribunal system that we've now got was entitled Tribunals for Users. Now, you might just dismiss that as sort of glib government PR babble. But I've no doubt that the focus in the reform of courts and tribunals that's now been started and is underway must be on the user. The question must be, what do the users of the system of administrative law want? And I would emphasize that is not necessarily the same thing as what the users' lawyers say the users want. Very often the last thing that a user wants is a day in court, in inverted commas. They simply want their dispute resolved as speedily and simply as possible. I simply pose the question, would not a tribunal-like approach be the best way to achieve that objective for the great majority of administrative law cases? We know that the upper tribunal, Immigration and Asylum Chamber, already deals with immigration judicial review. Why? Well, partly because the administrative court was completely overwhelmed by the amount of work, but more importantly, because the upper tribunal has the necessary expertise. We also know that in a number of areas of administrative law, the tribunal system, statutory appeal, has replaced the administrative court. Mental health, special educational needs, criminal injuries compensation, and so on and so forth. In the old days, many of those, any challenge would go by way of JR. Now it goes by statutory appeal to the first tier, the appropriate chamber of the first tier tribunal. And I pose the question, why stop there for administrative law cases? Why not an administrative tribunal to deal with administrative law disputes? We've actually already got, of course, an administrative appeals chamber of the upper tribunal, which deals with a very wide range of admin law disputes, including JR challenges in certain areas. And since administrative law, in my submission, shades off into maladministration, why should we have two systems for complainants, the courts and tribunals on one hand and the ombudsman on the other? Why don't we have one port of call for the citizen who wishes to complain about a decision by a public body, with the remedy being tailored to the type and degree of the error? When I was appointed Senior President of Tribunals, one of my concerns was that as the courts and tribunals became more integrated, they start sitting in the same buildings, there's interchangeability of courts judges and tribunals judges and so on and so forth, there was a danger that the tribunals would start to ape the courts, become sort of courts light. I think that that danger won't occur in this reform programme. I maintain the hope, actually, that matters will go in the opposite direction, and the advantages of an expert tribunal will be perceived as a way of making the administrative justice system more accessible and less costly to the ordinary citizen. Anyway, now I'm retired, I can happily put all of these questions. I don't have to answer them. My time has ended. I shall leave Maurice to answer these questions. And I simply say, looking back over the half-century, it's been enormous fun to be part of the exponential growth of administrative law. I'm quite content now to watch from the sidelines. Thank you very much for inviting me here to talk to you this evening.
Sir Jeremy, thank you very much for throwing down so many gauntlets and for making our task as lecturers in administrative law just that little bit more difficult. So Jeremy did say that he was willing to take some questions, and I think we may have time for a few questions. I'm looking at those who have an eye on the clock. So we can take a few questions if you have some, please.
Thank you very much for the lecture. I'm Alina from Kazakhstan. I'm doing a language international humanitarian law, and I'm very interested in the time limits for the citizens to apply to either court or ombudsman to appeal the decision of the public body. Like, do they have like 3 months, 6 months, or is it like no time limit, like according to the UK legislation?
Well, I mean, the strict answer at the moment depends on what sort of case you've got. If you're challenging a planning decision, now judicial review of a planning decision has to be within 6 weeks. Other decisions promptly and in any event within 3 months. And many statutory appeals will have different time limits. I think if there's a wider question, should there be a time limit, or time limits at all, my answer would be yes, because it seems to me that there are many cases where the wider public interest is in having some sort of certainty in the administrative law field. And so while from the individual's perspective it may be jolly unfair that they can't challenge something after X weeks or months or whatever it is, from the wider perspective, it's better that the decision remains. I appreciate that, I mean, applying the Ombudsman approach, there may be cases where you could have a slightly more generous time limit if all you were doing was giving some sort of recompense to the individual complainant, and there was no question of actually quashing the decision itself. Sorry.
So Jeremy, you used one ugly word, legalisation.
Yeah.
You came close to using another ugly word, judicialisation, talking about the relationship between courts and tribunals.
Well, I can't say judicialisation because they're here. They'd hear me. They'd be offended. I mean,
you nearly used the word ombudsmanisation. Words I did use when I was chairing the Administrative Justice Council. I'm a strong fan of the Ombudsman model. I'm delighted to hear what you said tonight. But there are many challenges. I've just completed a review of the Financial Ombudsman's handling of PPI complaints.
right, yeah.
1.3 million cases in about 3.5 years. But how does one begin to apply that model into the tribunal and court system? It's a model which depends upon a hierarchy of decision makers. In the courts and tribunals, you tend to get judges and sort of clerical workers. Ombudsmen have a hierarchy of people who are skilled at finding out the facts and making decisions. Heavy use of technology. And more crucially perhaps, neither a hearing nor a reliance upon the papers, as you put it. It's a reliance upon an ongoing dynamic process where the staff of the organisation, ombudsman, adjudicators, various levels, the most important instrument is probably the telephone and email. So they are gathering the facts over a 2 or 3 month process. How would you begin to import that sort of approach into the courts and tribunal system?
Well, 2 points. First of all, emphasis on the papers, and secondly, the staff. Taking them in reverse order, I think there's huge scope within the tribunal system for more work to be devolved down from judges to, whether you call them registrars or whatever, i.e. the equivalent of the ombudsman's legal officers or investigators. And I think as more and more applications come in online, the system itself will prevent people from omitting many things that they do now omit, and so the papers have to be sent back to them because they're incomplete and so on. So that effectively people will be almost forced by the system to complete the form, to complete whatever information they ought to be providing. And then, so far as looking at the papers rather than oral hearing is concerned, I don't rule out having any oral hearings. There may be scope for some, but I think the big difference between the old style written representations, which was very slow and didn't really enable the tribunal to, or the judge, to ask questions. Now you can do it online, email, by telephone con and so forth. You can have that immediacy without the people actually being in the room, so that online one party can make a point, the judge can ask a question, other party respond, and so on and so forth. It's all there, it's on the record, and so forth. So I think as you say, heavy use of technology and delegation where delegation is possible, I'm sure that's the way forward. Because, quite bluntly, legal officers are probably a jolly sight cheaper than judges. And you can reserve the judges for the things that really do need a judge's input. Because I think, quite a lot of time, interlocutory matters and so forth, almost spent getting the case together. Now, that doesn't have to be done, I would have thought, by the judges as opposed to the staff, if you like. That would be my feeling. Well, as Philip knows, there's already a lot of work now done by registrars in the tribunal system, and more could be done, I think.
I think the important qualification is that it's judge-led.
Judge, absolutely.
So that the decisions about what can be delegated and to whom are matters for the judges, not the administration.
Yes, rather like the Ombudsman. The Ombudsman decides what assistance he or she wants.
How do you build in a system of review or appeal to a judge where an individual is not satisfied with
Yeah.
the decisions of the registrar or legal officer?
And I think, as I understand it, experience has shown that the number of challenges by people aggrieved by registrars' decisions where we have introduced them in tribunals is very small, and the number of successful challenges is vanishingly small. So there's scope for it, a lot of scope for it.
Thank you for a great lecture. Very simple but very generic question. Except the proportionality principle, how much would you say that the EU legislation influenced the last 40 years of administrative law in the UK?
Well, I think specifically so far as administrative law is concerned, as I say, EU legislation might have influenced lots of commercial law and so forth, but specifically human rights law, obviously that aspect of EU law, if you're including human rights law in that, that's expanded yet again the reach of administrative law, because we have proportionality and so on and so forth. And also in certain ECHR contexts, judicial review has changed from being a review of the lawfulness of a decision effectively into an appeal on the merits. And as to what, just how intensive the review ought to be, and whether it's an appeal on the merits in all but name, is entirely context driven. And the courts will tell you which context you're in. So judicial review, for example, so when the Act says in terrorism cases the court applies the principles of judicial review, it doesn't apply the principles of judicial review, it actually conducts a merits review. That's the reality. Yeah.
Yes, you mentioned in your lecture, you mentioned that you're not very much in favour of the concept that courts will turn around to local authorities and say, you get to decide on this, or you make this decision, or you should do X, Y, and Z. Now, if I remember anything from my public law 2 lectures, and I know Andrew Swear sat right behind me, it is that courts have a thing of being very deferential to public authorities and basically telling them, go away and remake this decision. So, essentially, has there been a very quick evolution since what I learned, or is there some?
When did you learn?
Last year.
No.
Something else happened that we don't know of.
I would hesitate to say anything different from Andrew. No, my point was that the courts are indeed extraordinarily deferential to local authorities, but what they do in the sense that having found a legal error, aka I would suggest maladministration in many cases, they then remit it to the authority to decide the matter again. And it's precisely because, as things are presently constituted, the court finds it very difficult to assess the significance of the particular legal error, that they do that. And that's my argument about very often taking a sledgehammer, quashing, to quash things that actually in the overall scheme of decision making, if you had any expertise in the field, you'd say, this doesn't make a difference at all. But the court's very reluctant to do that, and that could be in part because we don't have the equivalent of an expert tribunal, which might be able to bring its own expertise to bear on, if you like, the significance of the particular type of legal error. Is a quashing really necessary? And as I say, I'm sure, being very deferential in that way, I've quashed numbers of decisions and on numbers of occasions, so I thought this is pretty pointless. They're just going to go away and take the same decision all over again. But, I mean, there we are. I didn't have much alternative. So, no, Andrew's perfectly correct. And I'm correct. I'm correct too.
I think we've got time for just one more question, please. There is one.
Just wanted to ask about the public bodies officials. Since the administrative law became so legalized, are there requirements for them to know a lot of legislation or be prepared in legal sense? Like for the public bodies authorities like
Well, it may well be the administrators don't themselves have to know a great deal of law, although in reality actually they probably do. It's simply in practice they have to have lawyers at their elbow, because if you want to know whether or not you've created a legitimate expectation or something, if you want to know whether you have to reconsult on something because a new idea has cropped up in a consultation process, you haven't asked about it in the first round of consultation, should you reconsult about it, the prudent administrator will run along to his or her administrative lawyer and say, what's the legal position? So, yeah.
Well, Jeremy, thank you very much once again for an excellent lecture. I think the lecture does display the importance of actually having events rather than virtual hearings. We could not have reproduced an event like this online. The questions and the discussion that it's generated, I think, is evidence of that. You've thrown down a lot of challenges for us, I think, as administrative lawyers, academics and students, which is exactly what we would have hoped you would have done. So we're really very pleased and we're very grateful. Thank you very much for your time, Sir Jeremy. Thank you.